The wait is over for thousands of families who have been separated for months or even years. USCIS has just released critical updates to I-130 processing times for 2026. And what you're about to learn could mean the difference between being reunited with your loved ones this year or waiting another 12 months in uncertainty. Whether you're petitioning for your spouse, your parents, your children, or your siblings, the information I'm sharing today will directly impact your immigration journey and your family's future in America. Welcome to US Visa Info, your trusted source for the latest immigration news, visa updates, and family-based immigration information. Today we're breaking down the 2026 updates to USCIS Form Y-130 processing times, which is the petition for alien relative that U.S. citizens and lawful permanent residents file to bring their family members to the United States. These processing times have changed significantly, and understanding these updates is absolutely crucial for anyone navigating the family-based immigration system. Stay with me until the very end because I'll tell you exactly what these new timelines mean for your specific relationship category, what factors are affecting processing speeds, and most importantly, what you can do right now to avoid delays and expedite your case whenever possible. Let's start with the fundamentals, so everyone understands what we're talking about. Form I-130, the petition for alien relative, is the first critical step in the family-based immigration process. This form establishes the qualifying relationship between a U.S. citizen or lawful permanent resident called the petitioner and their foreign national family member called the beneficiary. The I-130 doesn't grant a visa or green card by itself, but it's the foundation of the entire process. Once USCIS approves your I-130, the case moves forward to either consular processing, if your family member is outside the United States, or adjustment of status, if they're already here legally. The processing time for the I-130 is just the beginning of the journey. But it's often the longest and most frustrating part because families are essentially in limbo, unable to make concrete plans while they wait for approval. Now let's dive into the 2026 processing time updates for each family relationship category, starting with the category that most people are interested in, spouses. If you're a U.S. citizen petitioning for your spouse, the current processing time as of the 2026 update ranges from 11 to 17 months, depending on which U.S. Citizenship and Immigration Services Center is handling your case. This is actually an improvement from the 15 to 24 months we saw in 2024 and early 2025, which is encouraging news for couples who have been separated. The two main service centers that process I-130 petitions are the National Benefits Center and the PTOAC Service Center. And historically, the National Benefits Center has been faster, but this can change. For lawful permanent residents, meaning green card holders who are petitioning for their spouses, the I-130 processing time is similar, around 12 to 18 months. But there's an additional consideration. Even after the I-130 is approved, spouses of green card holders must wait for a visa to become available because they fall under the F2A preference category, which has annual numerical limits. U.S. citizen spouses don't face this wait because they're classified as immediate relatives with no numerical caps for those petitioning for parents, and this only applies to U.S. citizens because green card holders cannot petition for their parents. The processing times in 2026 are approximately 11 to 16 months. Parents are also considered immediate relatives, which means once the I-130 is approved, they can proceed immediately to either consular processing or adjustment of status without waiting for visa availability. The processing times for parent petitions have remained relatively stable and in some cases have even improved slightly compared to previous years. One thing to note is that if you're petitioning for both your mother and your father, you need to file separate I-130 petitions for each of them, which means double the filing fees and two separate processes, though they're often handled together by USCIS. When it comes to children, the situation becomes more complex because there are different categories depending on the child's age and marital status and whether the petitioner is a U.S. citizen or a green card holder. For U.S. citizens petitioning for unmarried children under 21 years old, these are immediate relatives with no visa backlog. And the I-130 processing time is approximately 10 to 15 months in 2026. However, there's a critical issue called aging out that families must be aware of. If your child turns 21 while the I-130 is pending or during the subsequent immigration process, they may age out of the immediate relative category and fall into the F1 preference category for unmarried adult children of U.S. citizens, which has significant visa backlogs. The Child Status Protection Act provides some relief by essentially freezing the child's age under certain circumstances, but it's complicated and requires careful calculation. For U.S. citizens petitioning for unmarried children over 21, this falls under the F1 preference category. And while the I-130 processing time itself is about 11 to 17 months, the real issue is the visa wait time after approval, which can currently be several years depending on the beneficiary's country of birth. For married children of U.S. citizens, this falls under the F3 preference category, and the situation is even more challenging. The I-130 processing time is similar, around 12 to 18 months, but the visa backlog after approval can be a decade or more, particularly for beneficiaries from countries with high demand like Mexico, the Philippines, India, and China. This is often a shock to petitioners who don't realize that filing an I-130 is just the beginning of a very long process. For lawful permanent residents petitioning for unmarried children under 21, this is the F2A category, with I-130 processing times of about 12 to 19 months, followed by a visa wait that can range from no wait at all to several years depending on visa bulletin movements. For unmarried children of green card holders who are 21 or over, this is the F2B category where the I-130 takes about 12 to 20 months to process, and then there's typically a multi-year wait for visa availability. Now, let's talk about siblings, which is one of the most backlogged categories in the entire immigration system. Only U.S. citizens can petition for their brothers and sisters, and this falls under the F4 preference category. The I-130 processing time in 2026 is approximately 13 to 20 months, which is actually not the worst part. The real challenge is what happens after approval. The visa wait time for siblings can currently be 15 to 23 years, depending on the country of birth. For countries like the Philippines and Mexico, the wait can be even longer because of per-country limits. This means that if you file an I-130 for your sibling today, they might not actually be able to immigrate until the 2040s. Many people find this shocking and unfair, and there's ongoing advocacy to reform this system. But for now, these are the realities. Despite these long waits, many U.S. citizens still choose to file I-130 petitions for their siblings to at least get in line with the hope that either visa availability will improve, immigration reform will happen, or at minimum, their siblings will have their place secured for the future. What factors are affecting I-130 processing times in 2026? There are several key elements at play. First, USCIS staffing and resources have been fluctuating. There have been efforts to hire more officers and reduce backlogs, which is why we're seeing some improvements in certain categories, but staffing levels still haven't fully recovered to meet the demand. Second, the volume of I-130 filings has increased significantly in recent years as more people have obtained citizenship or green cards and are now petitioning for their families, and as pandemic-related delays are finally clearing, allowing people who put off filing to now submit their petitions. Third, requests for evidence, known as RF, and the need for additional documentation can significantly slow down individual cases. If USCIS has any questions about the validity of your relationship or the documents you've submitted, they'll issue an RF, and the time it takes to respond and for them to review your response adds months to the process. Fourth, security checks and background investigations can cause delays, particularly if the beneficiary has a common name that triggers multiple matches in security databases, or if they've lived in countries where obtaining clear records is difficult. Fifth, processing center variations mean that identical petitions filed on the same day might have very different processing times depending on which service center they're randomly assigned to. Let's discuss what you can do to avoid delays and ensure your I-130 petition is processed as efficiently as possible. The single most important thing is to submit a complete and accurate petition the first time. This means including all required forms filled out correctly with no blank spaces unless they truly don't apply. All required supporting documents, such as birth certificates, marriage certificates, divorce decrees if applicable, and evidence of the petitioner's U.S. citizenship or lawful permanent resident status. Strong evidence of a bona fide relationship, which is especially important for spousal petitions and includes things like joint financial documents, photos together spanning the relationship, correspondence, affidavit from people who know you as a couple, and travel records showing visits. You should include certified translations of any documents not in English, done by a qualified translator with a certification statement. Submit clear, legible copies of documents. And if you're submitting photos, make sure they're labeled with names, dates, and locations. Pay the correct filing fee, which for I-130 is currently $675 as of 2026, and make sure your check or money order is properly filled out, or your credit card information is correct if filing online, should you file online or by mail. USCIS has been encouraging online filing through their electronic system, and there are some advantages. Online filing typically results in faster receipt confirmation. You can track your case status more easily. You can respond to requests for evidence online, and you receive notifications more quickly. However, some people prefer paper filing because they can include more extensive documentation up front. They have a complete paper trail, and they're more comfortable with traditional methods. Either way is acceptable, but if you file by mail, make sure you send it to the correct address based on the instructions. Use a trackable mailing method so you can confirm USCIS received it, and keep copies of absolutely everything you send. If you file online, save all confirmation numbers, take screenshots of your submission, and maintain electronic copies of all documents you upload. What happens after you file your I-130? First, you'll receive a receipt notice, Form I-797, within 2 to 3 weeks if you filed by mail or almost immediately if you filed online. This receipt notice confirms that USCIS has received your petition and includes your receipt number, which you'll use to track your case. It's crucial that you keep this receipt notice safe because you'll need the receipt number for everything going forward. After the initial receipt, your petition sits in queue, waiting for an immigration officer to review it. This waiting period is the bulk of the processing time. During this time, you can check your case status online using the USCIS case status tool by entering your receipt number. The status will typically show as received or cases being actively reviewed by USCIS. If USCIS needs additional information, they'll issue a request for evidence, and you'll typically have 87 days to respond, though the deadline will be specified in the RF notice. Responding quickly and thoroughly to an RF is critical because failure to respond will result in denial of your petition. If everything is in order, USCIS will approve your I-130 petition and send you an approval notice, Form Y-797. This is an exciting moment, but it's important to understand that I-130 approval doesn't mean your family member can immigrate immediately unless they're an immediate relative with current visa availability. If they're in a preference category, the approved I-130 establishes their priority date, which is essentially their place in line. The priority date is typically the date USCIS received your I-130 petition. Your family member must then wait until the monthly visa bulletin shows that visas are available for their category and priority date. This wait can range from no time at all to many years depending on the category and country. Once a visa becomes available, the case proceeds to the National Visa Center for consular processing. If the beneficiary is abroad or the beneficiary can file Form Y-485 for adjustment of status if they're already in the United States and a valid status. Can you expedite an I-130 petition? The short answer is that it's very difficult and rarely granted. USCIS has strict criteria for expedite requests and routine family separation doesn't meet the threshold. Expedite requests are generally only approved in cases of severe financial loss to a company or individual, emergencies and urgent humanitarian reasons, nonprofit organization requests on behalf of beneficiaries whose need furthers U.S. cultural or social interests, Department of Defense or national interest situations, or USCIS errors. Examples that might qualify include a beneficiary who needs urgent medical treatment available only in the U.S., or a beneficiary whose life is in danger in their current location. To request an expedite, you typically need to call the USCIS Contact Center at 1800-375-5283 or submit a request through the online account if you filed electronically. You must provide detailed evidence supporting your expedite request, such as medical records, police reports, or letters from relevant authorities. Even with strong evidence, Expedite requests are often denied, and there's no guarantee or appeal process for denied expedite requests. What about premium processing for I-130 petitions? Unfortunately, premium processing, which allows applicants to pay an additional fee for 15-day processing, is not available for I-130 petitions. Premium processing is only available for certain employment-based petitions and applications. This is a source of frustration for many families who would gladly pay extra to speed up the process, but USCIS has not extended premium processing to family-based petitions. There has been advocacy to make this available, but as of 2026, it's still not an option. Let's talk about what happens if your I-130 is denied. Denials can happen for various reasons, including failure to establish a qualifying relationship, inadequate evidence of a bona fide marriage, in spousal cases where USCIS suspects fraud, failure to respond to a request for evidence, petitioner not proving their status as a U.S. citizen or lawful permanent resident, or beneficiary being inadmissible to the United States for reasons such as criminal history or immigration violations. If your I-130 is denied, you'll receive a denial notice explaining the reasons. You typically cannot appeal an I-130 denial, but you can file a motion to reopen or a motion to reconsider with USCIS if you believe they made an error or if you have new evidence. You must file these motions within 30 days of the denial decision. Alternatively, you can file a completely new I-130 petition with additional evidence addressing the reasons for denial, though this requires paying the filing fee again. What are some common mistakes that cause delays or denials? One of the most frequent issues is insufficient evidence of relationship, particularly in spousal cases where USCIS is on high alert for fraud. If you've only known your spouse for a short time before marriage, if you had a civil ceremony with no family present, if you live in different countries with infrequent visits, or if there's a significant age difference, USCIS will scrutinize your case more carefully. You need to overcome this scrutiny with strong evidence of a genuine relationship. Another common mistake is errors or inconsistencies in forms. If information on your I-130 doesn't match information on other forms or supporting documents, like dates that don't align, names spelled differently, or addresses that don't match, this raises red flags. Missing signatures are another simple but critical error. Every form must be signed and dated. And if you're filing jointly with a petitioner and beneficiary, make sure all required signatures are present. Sending documents in foreign languages without certified English translations will result in those documents being disregarded and likely an RF. Some people also make the mistake of not disclosing previous marriages or immigration violations, thinking it won't matter or hoping USCIS won't find out. This is a serious error because USCIS will discover this information through background checks, and failure to disclose is considered fraud or misrepresentation, which can result not only in denial, but potentially in being barred from future immigration benefits. Always be completely honest and transparent on all immigration forms. If you have a complicated history, it's better to disclose it with an explanation rather than hide it and have it discovered later. Should you hire an immigration attorney to help with your I-130? This is a personal decision that depends on your circumstances. Many straightforward cases, like a U.S. citizen petitioning for a spouse in a first marriage with no complications, can be successfully completed without an attorney if you carefully follow instructions and submit complete documentation. However, there are situations where hiring an attorney is highly advisable. These include cases where either the petitioner or beneficiary has a criminal history, previous immigration violations such as overstays or unlawful presence, prior denials of immigration petitions or visa applications, complicated relationship histories with multiple marriages or divorces, situations where the relationship might be questioned, such as large age gaps or marriages that happen very quickly, beneficiaries from countries with complex documentation requirements or political instability, or simply if you don't feel confident navigating the process yourself. A qualified immigration attorney can review your case, identify potential issues, help you gather the right evidence, prepare you for interviews, and handle communications with USCIS. The cost typically ranges from $1,500 to $5,000 depending on complexity. But for many people, the peace of mind and increased likelihood of approval is worth the investment. Let's discuss some special situations and how they affect I-130 processing. If your beneficiary is already in the United States on a temporary visa, like a tourist visa, student visa, or work visa, you can still file an I-130. And if they're an immediate relative, they can potentially file for adjustment of status simultaneously using Form I-485, which is called concurrent filing. This can significantly speed up the process because they don't have to return to their home country for consular processing. However, if the beneficiary entered the U.S. with the preconceived intent to immigrate rather than as a genuine temporary visitor, this could be considered visa fraud. The key is the intent at the time of entry. If you were dating someone abroad, they visited you on a tourist visa, and you decided to get married during that visit, that's generally acceptable. But if you were already engaged or planning to marry before they applied for the tourist visa, that's problematic. If your beneficiary is undocumented in the United States, the situation is much more complicated. If you're a U.S. citizen and you're petitioning for your spouse or parent who entered the U.S. legally but overstayed, they may be able to adjust status in the U.S. despite the overstay. However, if they entered illegally without inspection, they typically cannot adjust status and must return to their home country for consular processing, which triggers bars to re-entry. This is an area where legal advice is absolutely essential because the rules are complex and the consequences of making a mistake can be severe. What about expedited processing at consulates after I-30 approval? Once your I-130 is approved and a visa number is available, the case moves to the National Visa Center, which collects additional forms and documentation, then schedules an interview at a U.S. consulate in the beneficiary's home country. Processing times at NVC and consulates vary widely by location. Some consulates are processing cases within a few months, while others have backlogs of a year or more. The COVID-19 pandemic created enormous backlogs at consulates worldwide, and while things have improved, many consulates are still struggling to catch up. There's generally no way to expedite consular processing except in true emergencies, and even then, it's difficult. The best approach is to respond quickly to all requests from NVC. Submit all required documentation promptly and correctly the first time, and prepare thoroughly for the consular interview. So there are no issues that would require additional administrative processing. Let's talk about what happens with derivative beneficiaries. If you're petitioning for your spouse and you have children under 21, those children can be included as derivative beneficiaries on your spouse's petition. They don't need separate I-130 petitions. However, you need to list them on the I-130 form, and they must remain unmarried and under 21 throughout the process to qualify. If you're petitioning for a parent and they have children under 21, those children cannot be derivative beneficiaries. You would need to file separate I-130 petitions for your siblings if you want them to immigrate as well, assuming you're a U.S. citizen, because only U.S. citizens can petition for siblings. For those currently waiting for their I-130 to be processed, here's what you should be doing. First, regularly check your case status online using your receipt number. While the online status doesn't update frequently and mostly just shows received or actively reviewing, it's still worth checking weekly in case there's an update or RF. Second, make sure USCIS has your current address. If you move while your petition is pending, you must file Form AR11 to update your address within 10 days of moving. You should also update your address on your online account if you filed electronically and contact the USCIS Contact Center to ensure the change is processed. Missing mail from USCIS because they have an old address can result in denials or missed deadlines. Third, keep gathering evidence of your ongoing relationship, especially if you're petitioning for a spouse. Continue to build your lives together. Document it with photos, trips, joint accounts, and save all correspondence. If USCIS issues an RF or if there's an interview later, you'll need to show the relationship has continued. Fourth, stay informed about visa bulletin movements. If your beneficiary is in a preference category, the State Department publishes the Visa Bulletin monthly, showing which priority dates are current for each category and country. This helps you understand how long the wait might be after I-130 approval. Fifth, maintain valid status if your beneficiary is in the United States. If they're here on a temporary visa, make sure they don't overstay or violate the terms of their status, as this could jeopardize the entire immigration process. One final important topic is the interview process that comes after I-130 approval, either at a consulate or at a USCIS office for adjustment of status cases. For spousal petitions, interviews are mandatory and are designed to verify that the marriage is genuine and not entered into solely for immigration purposes. Both the petitioner and beneficiary must attend the interview together. The officer will ask questions about your relationship, how you met, your wedding, your daily lives together, your future plans, and details about each other's backgrounds and families. The questions can be quite detailed and personal, and the officer is looking for consistency between your answers and genuine knowledge of each other. Some interviews are straightforward and brief, while others involve extensive questioning or even separate interviews where the couple is interviewed apart to check for inconsistencies. The best preparation is to be honest, to know each other well, and to review all the documents and information you submitted in your petition so you're familiar with dates and details. Bringing additional evidence to the interview, such as updated photos, joint bills, or letters from friends and family, can strengthen your case. That's everything you need to know about I-130 processing times in 2026 for spouses, parents, children, and siblings. The key takeaways are that processing times have improved somewhat compared to 2024 and early 2025, with most categories now in the 11 to 20 month range. But this is just the first step and doesn't include visa waiting times for preference categories, which can be years or even decades. Submitting a complete, accurate, well-documented petition the first time is the single best thing you can do to avoid delays. Being proactive, responsive, and organized throughout the process will help your case move as smoothly as possible. If this video has helped you understand the I-130 process and what to expect in 2026, please give it a thumbs up and subscribe to US Visa Info so you never miss critical updates about immigration processing times, policy changes, and visa news. Share this video with anyone you know who's navigating the family-based immigration system, because this information can help them prepare realistically and avoid costly mistakes. In the coming weeks, we'll continue bringing you detailed coverage of immigration topics here at US Visa Info. From visa bulletin updates to adjustment of status processing times, naturalization news, and everything you need to successfully navigate the US immigration system. Until next time, stay informed, stay patient, and remember that while the process is long, reuniting with your family in America is absolutely worth the